Oh. You might actually want to move to your left like 1 inch. There you go. All right, welcome everyone. I'm attorney Peter Harbach, and this is attorney Justin Randall. We're from Hooper Law Office, and you've logged into our ongoing webinar series on kind of all things estate and elder law. So today's topic is actually the top 10 common caregiver mistakes. So we're not talking about issues with like at-home caregivers, like contracted in or anything like that. We're talking about when family members or friends are trying to provide care to a loved one. A couple little housekeeping matters. If you're logged into the Zoom version of this, you can type in questions and we'll try and address answers at the end of the session. Unfortunately, we don't have a way to see Facebook Live questions or anything. But anything that we do receive, we'll try and get through them all. We've got a couple of minutes reserved at the end for any ongoing questions. And as a reminder, our next session is going to be Wednesday, May 20th, also at noon. For everybody who is registered, we've also got a couple of materials that we'll be emailing out if you've sent your addresses. One of them is the top 10 caregiver mistakes, that which is some of the content we're going to be going through. And then another one is a little graphic on things called activities of daily living, which are the main things that people need to be able to do to function, like feeding oneself, dressing, toileting, stuff like that. So I guess we'll just kind of jump into some content here. Number one is probably the most common error that we see that can cause the biggest financial problems for the families, which is when people are providing care for a loved one. It's common that they might have taken off of work, taken reduced hours, or quit their jobs entirely. And so the maybe parent or brother or whomever it is that needs the care is inclined to pay the person for their services. And their services are very valuable. And in many circumstances, it's absolutely appropriate for there to be an exchange of money. Well, when you have these relatives providing care, it is absolutely critical that there is a written, notarized caregiver contract in place. Because without a contract in place, if the person's care needs change substantially, where, boy, care at home is just no longer a reasonable thing that can be done, then the person might be transitioning into a facility for care. Well, if they transition into that facility and there's some kind of surprise of, oh, wow, this was more maybe expensive than we were anticipating. And boy, it's more than my income on a monthly basis to be in that care facility. Well, that means that they're going to need to start spending their assets down also on this care. Well, in many circumstances, people don't maybe have enough assets to afford ongoing care for a long period of time. So then they start thinking, boy, I might need to apply for Medicaid. And Medicaid has all kinds of rules when it comes to your finances as to whether or not you qualify for getting assistance from their program. Well, one of the rules that many, many people don't realize is that if you've been paying a loved one, like a child, to be providing care for you, they require, Medicaid requires that you had a notarized contract in place at the time these payments are getting made, or else on their end, they're going to say later when you apply for their program, hey, all of that money that you were transferring to the kids, we're going to call that a divestment because you didn't have a contract in place. And under Medicaid rules, divestments means penalties. So even if you're not anticipating or necessarily expecting that the person is definitely going to need Medicaid at any point, I don't know about you, but I don't have a crystal ball where I can know the future. And so this is just an incredibly painful problem for people to run into later. And it's never, this isn't the kind of thing where anybody was trying to be tricky or, trying to hide money or do anything underhanded, but then they get the bad results later for, I quit my job. Dad was paying me to provide care for him. I was spending 10 hours a day helping him out, but then it got to be too much. And, his medical circumstances got such that I just couldn't handle it anymore. And we just had to transition him into a facility. And then you find out, oh, now there's going to be a problem in applying for Medicaid because of those payments. And I've had numerous people, I'm sure you have also, Justin, where they've come in because now they're transitioning into this facility and we have to be the bearer of bad news saying, I think you're going to have a problem getting assistance in paying for care because he paid you for the last year or 2 years or something like that. And this is going to be a problem because you never knew you needed a caregiver contract in place.
Yeah, I've unfortunately had the situation where this has happened, and somebody had been paying for a couple years probably, and at this point the money was gone, and the person who had received the money, the caregiver themselves, no longer had the money, and so now there was no way for that person to give the money back and cure that gift, make sure that Medicaid says, okay, you returned all the money, that's we'll forgive that. Well, now the money's gone. And I mean, this is because of the fact that no one anticipates this causing a problem. So they spend the money like you would as any other source of income.
Yeah, they earned it.
Yeah.
And that's all seemingly legitimate, but there's just special rules that you absolutely want to make sure you're in compliance with so you don't get those kind of bad results later. So that is just a very sad one that we run into. In some circumstances, you can appeal to Medicaid and say, look, we didn't intend to do anything wrong. We don't have any kind of way to fix it, and apply for something they'd refer to as a hardship waiver. But, it's no guarantee that they're going to accept you through a hardship waiver in a circumstance like that. So the best advice you can follow is don't get yourselves in that position to begin with. We're not saying don't provide that kind of care with the family. That can be wonderful and very helpful to the parent or loved one. It's just make sure you have that contract in place, or else you can find yourself in a world of hurt later. Okay, another one. You're paying a child. Is that income to that child?
Yes,
all
absolutely.
Right.
Yeah.
What does that maybe mean for taxes?
It means you have to report that income on your taxes. And as with a lot of these sort of seemingly kind of under the table payments where, you're thinking, oh, I'm getting money from a family member. I don't have to report this. Well, that could cause a lot of issues. Not, just talking about the divestments being made on the parent side, maybe, or the family member side, but also the fact that now the caregiver themselves has not been reporting their income taxes properly, or maybe at all, depending on if that's their sole source of income now, for however long this has been going on. And so these types of things can cause issues, not just for the person receiving care, but also for the caregiver themselves.
Yeah, absolutely. I mean, this is it, regardless of whether or not a caregiver contract exists. If you're paying somebody for services, that's taxable income to them. And so, the caregivers themselves are supposed to be reporting that. Now, I've certainly heard from people before, who's going to know? I'm paying them in cash, but that doesn't mean that that's what's legal and that's what's required of you. If it's payment for a service, you have taxable income there. Also, there's a little conflict amongst tax preparers and whatnot over the right reporting of this, but many of them agree that if you are providing payment for care, this person really might be classified as an employee under a caregiver arrangement, which would require the filling out of Schedule H in somebody's tax return. So again, there's income tax that goes into even these sort of interfamily or intrafamily relationships. So you need to be aware of that. The next one is lump sum payments when it comes to doing caregiver arrangements. Now, a lump sum payment in Wisconsin is not accepted under the Medicaid rules. There are other states, I believe Florida, for example, where you can look at somebody's life expectancy and just say, oh, okay, we've got a 85-year-old and they have maybe a 3.5-year life expectancy. And so it would be reasonable to pay, and I'm going to make this number up, say $250,000 to somebody if they'll agree to care for the person for the rest of their life. And that would be what we would call a lump sum caregiver contract. In Wisconsin, if, again, there's any potential that somebody might be applying for Medicaid, Wisconsin rules don't allow that kind of an arrangement. So it has to be a consistent payment. You can't just throw a couple $100,000 at them and say, okay, care for me for the rest of my life. And again, it's not because you absolutely intend to need that, custodial care or transition into a facility. But like I said before, you just never know what situation you're going to be in, and those lump sum arrangements can have penalties. So that can be a problem here in Wisconsin. Other states, that's okay, but not here in Wisconsin. What would happen? Would you take any issue with our next one, which is, hey, I'm going to set up my will or my trust, and my daughter's helping me around the house or whatever, and so she intends to continue. Any potential problems you see with changing around the estate plan as like the way to compensate this person?
Yeah, the biggest issue I could see with that is if this individual does end up receiving care and is eventually qualified for Medicaid, even if they qualified and the assets were still around, possibly because they were married or it was an exempt asset, something like that at the time, a state recovery can still come back and take that. And a state recovery, if you're not familiar, is when Medicaid basically comes in as a creditor to the estate and says, hey, we provided this much in value to you, now you have to pay it back.
Okay, so basically what you're saying is if you change around the estate plan to say, oh, I'm going to give my daughter an extra 20%, and because maybe she's been helping out, and so this is going to be what she receives for all of that effort, there's a possibility she never actually gets it.
Exactly. Yeah.
Because especially if somebody needed care and was in a facility and needed to apply for Medicaid, it's very likely that there's nothing in the estate to cover that 20%. Another issue is that you might be looking at the estate right now to figure out the value, but number one, the care hasn't been provided yet, and you don't have an expiration date necessarily, so you don't know how long the care is going to go on. So you're trying to predict not just the size of the estate so that you know what percentage might be appropriate, but also the amount of work. I mean, if you rearrange your estate plan, oh, I want to give her an extra 20% because she's going to be providing care, and then you get hit by a bus the next day, that's really a kind of a windfall to the daughter at the expense of the other beneficiaries. And if she hadn't been providing care over that period of time, there can be some hard feelings amongst the family. Oh, you got all of this, but you never really earned it.
Well, and another issue too, just kind of with practicality. I mean, if you're promising that and then you never actually get around to updating that plan to begin with, and then
another problem,
and then they do provide that care, even if you never have a state recovery issues, then maybe they still don't get compensated for it.
Yeah. So just a lot of potential risk in trying to establish it that way. Because there's too many unknowns about the future. It's almost like giving a lump sum payment at the end, but trying to predict what that's going to be ahead of time. Just numerous problems with that type of thing. Okay. Another one is signing the house or gifting the house over to a child. because maybe they moved in and we're helping provide care, and all right, so they're going to get a spot to live. Any advantages or pitfalls of looking at it that way?
There are certain ways in which this can work, but you do have to follow the proper, parameters that you're given. There's things like the child has to have lived there for 2 of the last 5 years providing care, and they do have to be consecutive 2 years as well. And they had to have been actually providing that care with that caregiver agreement as well.
Yeah. So yeah, the child would have had to have provided 2 years of care immediately before the institutionalization of this person. 2 out of the 5 is even better, just because there's a tax ramification for if it's your primary residence and you own it for 2 of the last 5 years. When they then go to sell it, they don't have to pay capital gains taxes on it.
Right.
But then on top of that, if they've lived there for the last 2 years and have been providing care over that period of time, and then you say transition into a nursing home, if you can provide evidence, and generally the best evidence is going to, for instance, come from doctors who are familiar with the care needs of the parent over that couple of year period of time. If they'd agree that, boy, if this kid hadn't been helping out, they would have been into a facility, 2 years ago. Or 5 years ago, or however long that care had been provided. Again, minimum of 2 years there. Well, then the parent can transfer the house over to that child without it being considered a divestment or a gift that causes problems with eligibility through Medicaid. There's numerous issues with this, partially because you have to be institutionalized in order to be able to make that gift. And a lot of people, it would end up only applying if they end up in a skilled nursing facility and their situation doesn't work out if they don't need skilled level of care and instead have to transition to an assisted living facility or CBRF. So it's tough to rely on that. I wouldn't call that exemption planning. Sometimes it's used in a we have no other kind of tools scenario where this is just the situation we're presented with, and so we have to make the best with it. But if you're being proactive, there's much better arrangements that can be made to make sure that any transition into a care facility, the house ends up going where you want it to go, and a lien isn't put on there by the state.
Yeah, and the issue with the 2 years as well is like you're saying, it's not planning. You don't want to keep someone home longer than they should for health reasons, especially because of the fact that you're just waiting for the 2 years to come up.
Yeah, you brought up one of the most important points when it comes to long-term care planning. You want to make smart financial decisions, but they should always be secondary to what's the best thing for the person who needs care. What is the best situation for them to be in? Where are they going to have the best quality of life? Is that at home? Is that in a CBRF or a assisted living facility or a skilled nursing facility? Nothing should trump the care needs of the person. But then it's how do we be smart in the context of what they need? So that's a brilliant point. That's absolutely the way you want to be focused on these things. Another really common issue that we run into, where maybe it's not even so much care that's getting provided, although it's unbelievably common for this to happen when care is getting provided by a child, but there could also just be arrangements where I need to help mom and dad out with some things, like I do all their grocery shopping for them, or I run and get them items when they need them, or I run to Walmart or Menards, or I do their shopping for them because they're just not that mobile. Well, one issue that we want you to watch out for is a lot of kids will go and just use their own credit card or their own checks or debit card to go buy these things, and then the parent writes a check to the child, reimbursing them for whatever kind of expenses they might have had, because they bought something for the parent, and the parent's not looking necessarily for a handout. They're just, hey, I'm struggling to get to the store myself. Can you get me this stuff?
Mhm.
Well, when the child buys that and gets reimbursed from the parent, what it can end up happening later is maybe their situation health-wise gets worse, these parents, and they have to transition into a care facility, maybe don't have adequate funds to just pay for the rest of their lives. And so maybe they run out of money a couple of years after going into the facility, and they've got to file for assistance in paying for the care. Well, on a Medicaid application, the caseworker can request 5 years of financial statements. And so they can look through, okay, what's been going on in any of these accounts over the last 5 years? And if they see a bunch of consistent checks going to a family member, they're going to question, well, why has that been going on? And if you can't provide receipts for all of these things, well, then they're going to potentially just assume, wait a minute, how do we know they weren't just trying to gift them money because they didn't want it to end up going to the nursing home? They didn't want to pay for care later. So, hey, we're going to take issue with all these checks you've been writing to your child. So the fix for that is, if you're buying things for their parents, it's good to just use the parents' money directly. Become the power of attorney and spend the money right from their account to Walmart or to Menards or wherever their expenses are. So they're not showing up as payments to the child that keep happening, where you then have to justify them later of, no, we weren't trying to hide money or anything like that. I kept all of these receipts. That can be a big pain in the butt. And I don't know about you, but I don't have every grocery shopping receipt from the last 5 years.
No, I
don't have space to keep all of that. I don't think anybody in the universe is that organized where they either keep them or want to have to go through that kind of organization.
Yeah, you're allowed to pay for goods and services. That's not a divestment. So if they see on your bank statements that, okay, Festival Foods received, a payment of $60 for your groceries, that they're okay with, because they know you were buying groceries or buying something from the store directly. If they see it go to the child first and then don't know what happened to it after that, that's the issue.
Yeah, absolutely. Next issue, and I guess we're going to have to speed up a little bit. We're going to be running low on time. Cut down some of the explanations a little bit. Next issue, very simple. Paying the spouse and thinking that that's a way to reallocate assets or keep things safe from a nursing home. Paying a spouse doesn't do anything in regards to that. Generally speaking, for the majority of assets, it's not going to make any difference whose name is on the account. They're assets that are countable for nursing home expenses. An exception to that is, for instance, IRA money, but you're not paying into some spouse's IRA. So generally reallocating assets through paying a spouse, it just doesn't do anything. Same thing with splitting out accounts. I kept it all in my name so that I wouldn't be subject to my husband's nursing home costs after I got 50 grand in an inheritance 10 years ago from my mom. Doesn't do anything. That's still countable assets. Thinking paying in cash. Oh man, does this one come up a lot.
Yeah. Paying
in cash is going to avoid, because who's going to know?
Yeah. It's a similar issue to when you're reimbursing someone for buying your groceries for you, right? If you can't prove where that money went, you don't have receipts of what happened, and especially if you don't have the caregiver agreement in the first place, all of those things combined, it's still an issue.
So you, in your opinion, having on the financial accounts, $600 in cash withdrawals, that might raise a red flag,
especially if they're in regular time frames. Once a month this $600 is being withdrawn and there's no explanation for it.
Yeah, again, we're back to maybe having to prove totally innocuous things, but paying in cash to avoid the idea of anybody finding out about it, that's not innocuous. That's a problem. And again, we want to be clear that nobody wants to be lying on a Medicaid application. That's completely illegal. We want to follow the law, but get good results. And following the law does not include lying to people about different things. Another one, buying large gifts as opposed to doing regular payments.
Mm-hmm.
It just doesn't get you anywhere. If you're buying a large gift, anything that you're transferring for less than fair market value, with very few exceptions, is going to be considered a divestment. And so you're actually worse off doing large gifts in most instances than doing regular payments under a contract. So, buying your kid a Ferrari because they took care of you for a few years, and it doesn't work. Again, don't try to be sneaky as a way to think you're outsmarting anybody. It's much better to have a good understanding of the rules and then just follow those rules. Right. And the last one we want to bring up would be, I guess, the caregiver, the family member, overworking or working beyond their capability and capacity. I can't tell you how many times I've dealt with clients and they're experiencing kind of caregiver burnout, where it can actually result in feelings of resentment or almost guilt on their end. Resentment maybe towards the parent for what they've had to give up in this caregiving, and also guilt on their own end that, are they doing the best job? Feeling bad about getting frustrated in some circumstances, and just, caregivers need to understand their own kind of limitations, and that it's okay to get help and to take breaks and, lead somewhat of your own life as well. Yeah. And in particular, spouses. I can't tell you how many families where we've got a couple of 80-year-old spouses, and one of them is just killing themselves to provide care to their husband or wife to the detriment of their own health.
Yeah, and it's just not uncommon to see the spouse providing care or the loved one providing care actually suffer in health more so than the person they're providing care, because they're not taking care of themselves.
Oh yeah. That sort of deterioration because of the just overwhelming, physical and mental strain that they have on them being, the sole or primary caregiver. And so, I would just encourage everybody to do a self-assessment of, how am I doing here? And do I have the support that I need? It doesn't necessarily mean that you've got to transition the person into a care facility right now, but maybe you really need to look at getting some, respite care, getting some help from an outside agency to provide some level of care. And then there's ways to work through, being able to finance this kind of stuff. And, that's where elder law attorneys can be very helpful, knowing the different programs and how your composition of assets fit into your qualifications for these programs. So that's where, again, an elder law attorney brings a lot of value to the table. Mm-hmm. But just, again, self-assess and make sure, because, if you don't want to burn out and want to be in it for a long haul, you got to take care of yourself as well. So that's the basics of our program. We'll be sending out a number of different materials for everybody who is registered. Again, our next class is going to be Wednesday, May 20th. If anything that we talked about today, or frankly at any of these classes, kind of rings true to your current situation, and you need to, explore options or pursue something within your own plan, feel free to contact our office. We do initial consultations without charge, and then in most instances are able to quote fixed fees to help in these types of circumstances. So that's just a little plug for us if you need any assistance with this stuff. So I want to thank everybody for listening. Again, I'm attorney Peter Harbach, and this is attorney Justin Randall. And we hope to see many, if not all of you, next week. Again, noon, May 20th. And I hope you found this to be a useful way to spend your time here during the quarantine. So everybody take care and be safe.